Good day to you all. My name is Chuck Dick. I have the privilege of being one of the three co-chairs of the programming subcommittee of CalArb. And today I am doubly pleased to be given the privilege of conducting another in our series of interviews called California Conversations. I'm particularly excited about today because we have really one of the more prominent members of the San Francisco ADR community with us today. We're going to be spending some time getting to know Grant Kim. And Grant, I'm delighted to welcome you to California Conversations, to our viewership, and welcome, as I said, to this one in a series of programs where we're introducing notables of the California ADR community to the world at large. Welcome again.
Thanks, Chuck. I'm looking forward to it, and thank you for the gracious introduction.
You know, I must say, Grant, for those of us who are transplanted to California, and that certainly includes myself, to run into somebody who is now generations old in California. Your grandparents, as I recall, migrated to the United States over 100 years ago. You are multi-generational Californian, and you've seen much of what has developed here in the legal community, particularly with respect to ADR during the course of your time in California. So I'm especially interested in knowing how you, from Southern California, entered into this arena. And let's start by just telling us a little bit about your background, your educational experiences, and what led you to where you are today.
Yeah, thanks, Chuck. Yes, I was actually born in downtown LA. And I remember as a kid growing up, even then, a lot of the people around me were people who were born somewhere else and moved to California. So I was born and raised in Southern California. And after that, I went to law school in Northern California. I've been in Northern California for most of my career. So for most of my life, I've either been in Southern California or Northern California, except when I was overseas. I was in Korea twice for almost, 7 or 8 years. I was in Japan for a couple of years, and I was in France for a number of months. So that's
part of that has given rise to some multilingual capabilities on your part. Did you speak Korean in your home when you were growing up?
No, as you mentioned, Chuck, it was my grandparents came here over 100 years ago. My parents were raised in the US, so English was their native language. And they spoke some Korean, but it was secondary. So in our home, we just spoke English. When I went to my grandparents' house, I spoke a little, hello and goodbye in Korean, but that was about it. And so that was my background.
But after college, as I recall, you spent some time in Korea teaching
Yes.
English. And tell us a little bit about that experience for somebody who doesn't speak Korean as a native language.
Yeah, thank you. So I took a little detour first. I actually, in college, I was lucky to go to a college that had an excellent study abroad program. So even though I wasn't a French major, I ended up going to France for a semester in the spring, to Paris in the spring, which was fantastic. And my French was not very good when I got there, but it certainly did improve. And I just discovered the magic of living overseas, and that, I really learned more in that one semester there than I did the rest of my college career. Mostly outside of the classroom, but, inside too. But I just discovered the world is this huge place, and there are all kinds of people doing all kinds of things. I traveled around Europe and saw a lot of different things, and I was like, wow. So after I got out of college, I was just a general liberal arts major with no marketable skill. So I looked around and said, what should I do? The only thing I knew is I wanted to live somewhere else. And I ended up having an opportunity to go to Korea, which I had never thought about going. I am, of course, Korean, so I had some interest. But, to be Korean and you don't actually speak Korean is kind of, it's a little awkward. And I have to mention also, now there are, of course, tons of Koreans in LA. The time I grew up, like in the 60s and so forth, and we were in a suburb, there were no Koreans around me, just my family, my uncle, my grandparents. So there was and they were all pretty American, having come here a long time ago. So I didn't have any reference point. But I went to Korea, taught English. It certainly changed my life in good ways. And but I was like basically a reverse immigration experience. I went to Korea knowing like 5 words of Korean, and I had to learn. And I figured, well, I lived in France. I spoke some French, not fluently, I had actually even studied some other languages. I said, okay, no problem. 3 months, I'll pick it up. Well, it turns out that learning Korean is way harder for an English speaker than learning like a European language. So after 3 months, I was kind of barely surviving. And of course, it was a very intense experience, but I survived. I was teaching English there. I was there for several years. I actually met my wife there. That was not the plan, but I have to tell you, it's an excellent way to learn a language. Motivation, So it changed my life in many ways. Then we got married and went to law school. And then a bunch of other things happened.
So you came back to the United States, San Francisco to law school, as I recall.
Yes.
Tell me about the choice of coming to Northern California for your legal education.
Yeah, well, so, when I was in Europe, I fell in love with the idea of public transportation. You could take trains everywhere, subways everywhere, buses, and, you could it was kind of more empowering. LA is a bunch of cars and shopping malls. There are obviously some good points about LA, but I always kind of liked visiting San Francisco as a kid. And I knew, I was just a student and I didn't have the money to really buy a car. So I figured somewhere with good public transportation, that would be a good place. And I was at, it's now UC Law San Francisco, that time UC Hastings. It was almost free at the time. So it was great. It was quite an experience. But I have to say, the first time I moved to San Francisco, I had culture shock from coming from LA. It's like, I got there in August. It's like, what happened to the sun? There's just fog all day. And I was like, what the heck? I've visited before, but I didn't realize it was so foggy. And, I'm American. My wife, who was from Korea, it was pretty intense. Yeah. We were actually living in the middle of the Haight-Ashbury district too. So it was quite something. But, you could walk around and you could just, if you want to buy a baguette or something, you could just walk down the street or buy some tomatoes. You didn't have to get in a car and go places. So you could walk to Golden Gate Park. It was a different kind of cross-cultural experience, but it was great.
After law school, tell me a little bit about your migration into the legal community. And I know you started with big law, but how in the world did you get into international law?
Yeah, well, actually, the starting point is, like many kind of young idealistic people, I went to law school with the idea I was going to change the world or do public interest law, so forth. In the summer, I actually worked at like Legal Aid Society. But after law school, I ended up doing a 2-year clerkship at the central staff of the Ninth Circuit, which was a fantastic experience. So it was kind of a little bit of buffer. I didn't have to look for a job right away. And then people said, well, if you want to try out a big law firm, you should maybe consider Morrison Forster, which is where I went because they have a good pro bono program and so forth. And so I tried that out. I never imagined that I'd end up staying there for many years. I just thought I'd try it. But it turned out my timing, well, I had good luck. When I joined, the firm was not particularly international. It was not into patent litigation, other technology disputes, but I joined just around the time it was getting into both. And when I joined, they said, Grant, well, what kind of case would you like to work on? You could work on banking litigation, or we have this top secret arbitration. We can't even tell you the name of the client, but it involves computers and trips to Japan. Well, that was kind of a classic no-brainer. I said, oh, okay, I'll take that secret case, and computers and trips to Japan. So I thought, fantastic. And eventually, because of that case, I ended up actually moving to Tokyo and living there for a couple of years. Our first son was actually born in Tokyo. And it was an absolutely fascinating arbitration, massive bet the company case. So big, we had multiple attorneys who actually just moved to Tokyo and were working with the client there full time on this single case. It was for Fujitsu against IBM. I could say the names of the parties now. Fascinating case. So that was, at the time, the biggest international arbitration ever. So it absolutely whetted my appetite for international arbitration. It was a long time ago. It was like the late 80s, and it was completely non-standard. It was not directly useful for other arbitrations because the procedure was very different. than the typical international arbitration procedure. But what it taught me is I always thought that lawyers who wanted to go overseas had to do corporate law. But I realized there was a possibility of doing international arbitration. I didn't know about that at all. So after I found out that's exactly what I wanted to do. But when I came back, there wasn't enough work around then. This was still pretty early, even globally in international arbitration. There just wasn't that much around, and certainly in California. But at that time, patent litigation and generally disputes about technology and IP were on the rise. So I started getting involved in that. Now, I have a general liberal arts background, but I did actually start as a math science major. So I'm not a specialist, but I'm not afraid of technology. And I found these cases were just wonderful because you actually get paid to learn about cutting edge technology. A lot of times I'm working with these world-class experts thinking, boy, I should be paying a huge tuition, but I'm getting paid to do this. And then it kind of stretches your mind. You first have to learn about it, but then you have to explain it to a judge or a jury or an arbitrator in a way they can understand. And I love that challenge, and it was a great fit. So I did that for a while. I did do at least one big international arbitration, which was a dispute between a Korean company, our client, and a Silicon Valley company arising from a technology transfer agreement. And that definitely got me even more interested in international arbitration. But after I'd become a partner for a number of years and I was doing this stuff, I thought mostly for personal reasons, it would be nice to live in Korea. My wife, as I mentioned, is from Korea. All our family's in Korea. When she married me and moved here, she didn't know anybody here other than me. So it was a big plunge for her. And I knew from my experience moving to Korea how hard it is to live in another country. So I thought it would be nice to live there. And also we had 2 sons at the time. And I thought for them, it would be great for them to have a chance to live in, their mom's native country. So, but then the question is, what am I going to do there? And I ended up moving to Korea over 20 years ago. Again, I got lucky. At the time, international arbitration was not a big thing in Korea. It is big now. But it turns out that I got there just as the market was starting to heat up. So this was after the Asian financial crisis in like 1997. And after that, there were a lot of big M&A deals, like multi-billion-dollar deals. And then after that, and there were a lot of big arbitrations, because some of those deals ran into problems, and then there was a big fight. And of course, not all of them were multi-billion, but these were big cases. But I joined the largest firm in Korea, Kim and Chang. But I was actually part of a startup group within that large firm, because when I went there, they actually didn't have an international arbitration practice group. Of course, Morrison Foerster and most US firms also didn't have international arbitration groups. So they just had litigation groups. And if arbitration came in, it would be handled by whoever was handy. Well, it turns out if you're doing domestic arbitration, that's not so hard. If you're doing international arbitration, it's possible, but there are parts that are significantly different. I'd say 70 or 80% will carry over, but that 20 or 30%, it usually has to do with the procedures and how you approach things. You got to be able to adjust. And I found that US litigators who can do that do very well. There's some people who just, I just want to do jury trials and so forth, and they can't adjust. But people who can change their mindset and adjust tend to do very well, because I think in the US, for better or worse, we're litigation crazy and we have great litigation training. So as I mentioned, then I went to Korea. That's how I really got into international arbitration, because when I was in the US, I was 95% doing litigation with an occasional arbitration. When I went to Korea, it was exactly the opposite, 95% international arbitration, with occasionally I was helping colleagues with like litigation in Korea where there was a foreign client or other issues.
How long were you there?
So I was there for almost 5 years. And it was a fantastic experience. I got to be, as I mentioned, I was a startup within a very large firm. We built a practice, we built a group. And there were people, of course, who had done international arbitration there before, but the firm had not really acted as lead counsel overseas in big international arbitrations. They were usually secondary counsel or primary counsel for domestic arbitration or international arbitration in Korea. So I worked in the 4 or 5 years I was counsel in about 12 different cases, and I had 4 merits hearings, arbitration trials as lead counsel, which is way more trial experience I would have gotten than if I just stayed in the US. So it was fantastic. There were some challenges of, being a startup and building a practice, but there were fantastic opportunities. And that, as you said, I got lucky in terms of timing. When I got there in 2000, Korea was completely unknown in the international arbitration community. By 2004, it was starting to get known. People were starting to notice. And a few years later, it was all the talk. It was like, where did Korea come from? So.
Well, tell me about your thought processes in deciding you wanted to return to the United States and specifically California.
Yeah, well, so the issue that happens when you go overseas typically is you learn amazing stuff and you become very, very valuable in that particular position. But there comes a time where you have to decide, do I just want to stay here forever or do I want to come back? And if you stay away too long, it gets hard to come back because things don't, transfer immediately. So at that time, well, I have a foot. Certainly, I'm more American than Korean, but all my family's here, and we had these 2 kids who were getting older. One was in high school, and he should be going to college soon. So we kind of thought, well, it's probably time to go back to the U.S., right? So we decided to do that, and yeah, I think it worked out well.
And that was a return to San Francisco. Tell me about the next steps in your professional life.
Yeah, well, so we came back to the U.S. and professionally, from that point on, I did about 50-50 international arbitration and IP litigation, other commercial litigation. And of course, my sweet spot, and I had several of these cases, were international arbitration that involved IP disputes or technology disputes. I had one, for example, an ICDR arbitration in Switzerland involving biotech for a Silicon Valley company. Absolutely fascinating case where I could use my international arbitration skills and my IP litigation skills in the same case, as well as kind of the cross-cultural skills I picked up living in various places. I didn't, I'm not particularly Swiss, an expert on Swiss culture. I do know some German. It was in Zurich. I know more French, but the ability to kind of think differently. For example, we had 3 Swiss arbitrators, and they proposed some procedures that were a little different from the U.S. and to think flexibly and to adapt to that. Very helpful.
Grant, I know that your practice today still includes both work as an advocate as well as functioning as an arbitrator, either by yourself or as a member of a tribunal. And that presents, for some people, some interesting challenges. You've conquered those challenges and have developed a very interesting professional life. And I just wonder if you could share with us some of your observations about how you've melded the varying responsibilities of advocacy versus functioning more in a judicial fashion.
Yeah. Well, that is a good question because high stakes litigation tends to be all consuming. If a case is really hot and things are going fast, it can be difficult to juggle that because obviously as an arbitrator, and of course I've done both international and domestic arbitration as an arbitrator, you need to be responsive. You can't just say, oh, sorry, I'm too busy now. So one thing is, though, going back a bit, when I was at my big firm, I was definitely interested in becoming an arbitrator after I had enough experience. And in fact, I was very lucky. One of my very first assignments when I joined Morrison Forster many years ago was for one of our very senior partners, Bob Raven, who became president of the ABA. And he was serving as an arbitrator in a case. And he basically asked me to help him with the case. And since I just came from the Ninth Circuit, I said, wow, this is great. I know it's like being a judicial clerk. I know how to do this, right? So it's an easy way in. Anyway, I was very interested in it. I was very active in networking with different arbitral institutions. And I was active in like the Chartered Institute of Arbitrators, other groups. but I wasn't, and I got on some lists, like the list, ICDR list of arbitrators, but I was not getting appointed as an arbitrator. And I think the big reason is it's just not compatible with a big firm. There are way too many conflicts. And the firm doesn't really want you to do lots of international arbitration. Because it's not a leveraged practice. It's not that profitable, right? So it was clear I would have to move if I really wanted to develop my practice as an arbitrator. If I had enough cases as an arbitrator and enough reputation, I could just go solo and be a solo arbitrator. But I just wasn't even getting appointed in the first place. I had 1 or 2 cases. So I decided, a friend of mine had founded a small, a boutique minority-owned law firm, LimNexus, which is where I'm at, many years ago. I met him in law school many years ago. And he said, yeah, come on over. And I wasn't quite sure because after all, it's a big firm and, could I actually adapt to the small firm? I didn't want to go over to my friend's firm and then, not actually be a good member of the firm. But we had a flexible arrangement in the sense that I could do some arbitration as arbitrator, and I also do arbitrations as counsel or litigation as counsel, and it was a good fit. So that was about 7.5 years ago. And I knew it would take time to develop my practice as an arbitrator. It actually took longer than I expected. I thought a year or 2, but it took more like 3 or 4 years. But it's going pretty well now, and I get a number of appointments as an arbitrator. I still serve as counsel in some cases. The mix varies. I think in terms of your question of how to balance, it's a little tricky because, of course, litigation and arbitration, you don't know exactly what's going to happen next. But I've been fortunate. And one thing that is helpful, arbitration, you tend to know your schedule pretty far in advance. And it's less, there are still unpredictable events that happen, but you have, in litigation, there's always unpredictable stuff happening. So it's easier to schedule around stuff. But anyway, I just found the right environment to be able to do both, and it's been going well.
Well, describe for us a little bit, if you would, your philosophy about serving as an arbitrator, as a neutral, and the kind of approach that you like to bring to the process.
Yeah, thanks for the question. That's so what I think that certainly from I definitely bring my experience as an advocate. And one thing as an advocate, I really want to make sure that the decision maker understands what I'm saying and I get a fair shot. So as an arbitrator, I'm balancing 2 things. One is kind of fairness and opportunity to be heard, and the other is efficiency. And those can go together, but there is some tension. I mean, if you just keep, for example, allowing new evidence in at the last minute, that's, yeah, you're giving people an opportunity to be heard, but the process will drag on, and it's not really even that fair to allow just new evidence, surprise evidence to, show up at the last minute. So I would overall say my approach is balanced. I try to be both fair and efficient. I like to give everybody a reasonable opportunity to be heard. I like to let people know kind of my preliminary thoughts, what issues I really want to hear about. I mean, there could be lots of different arguments as an advocate, I always want to know what is the judge thinking or the arbitrator so I can address those issues. I don't want to waste my time on things I'm already winning on. If I'm losing on something, I want to kind of know so I can address it. So I try to give ample notice of that. The other thing in terms of procedure, and one thing I really love about what I've learned, is there are lots of different procedures that can work when administering an arbitration. In particular, there's kind of the US domestic approach, which is more like US litigation, but a bit toned down. There's the international arbitration approach, which kind of combines parts of civil law and common law. And you can mix and match and try to figure out what works best. And you can definitely tailor your procedures to your specific case. So I talk to the counsel and I try to figure out what is going to be the best way to resolve this case. And I love that flexibility. Some people complain, oh, arbitration, there are no rules. I don't know what, I don't know what's going to happen. Well, what people don't understand, it's up to you, the advocate and the arbitrator, to use that flexibility in a positive manner. Figure out what works. You don't have to do it that way. You can suggest something. So for example, that biotech patent arbitration I mentioned in Switzerland, we knew it had a huge learning curve. And I pride myself on being able to learn new stuff. But when I first picked up the patents of the issue, I couldn't get past the first sentence. I had no clue. I'd even done some biotech before, but I didn't know what it's talking about. And we wanted the arbitrators to understand the technology. So at a very early conference, we said, here's the standard schedule. Okay, we'll do that. But what we suggest is to do a tutorial where we just come in for a day and explain the technology to you. It'll be off the record. It's just so you understand it. And we're going to do it very early. It's not going to be at the last second or at the merits hearing. It'll be like in the middle of the case. And the point is that without that education, you read the expert reports, you have no clue what they're talking about, right? And what was interesting was the arbitrators not only said yes, they were really enthusiastic. They said, that sounds like a fantastic idea. Let's do it, right? So we definitely use the process to our advantage. And although, theoretically we weren't arguing the merits, I think we basically won on certain non-infringement defenses at that hearing once they understood what was at issue.
Did you have difficulty getting your opponent to agree with that approach?
I was very surprised. They did not. Yeah, usually there's the one who's strong on technology wants the education. The one who's not does not. They just want to confuse them, right? And we knew, of course, we were strong on the technical issues. They didn't oppose it at all. I'm not sure. It was a Swiss law firm. Maybe they didn't. Maybe they just knew it would be. There was no way they were going to win, or maybe they felt they were strong on technology. Maybe they didn't understand their case as well. I mean, it was clear the arbitrators were going to want to do it, but I was surprised they didn't put up more opposition. Getting back to your question about philosophy also, in terms of this question of balance, for example, another issue is the scope of discovery. So US litigation is kind of famous or infamous for having massive discovery, which is very burdensome and intrusive, but sometimes can be useful. International arbitration, American lawyers always complain, like, why is there no discovery? This is crazy. I mean, it's, you get some limited document production, but nothing like the US, and you don't usually get depositions or interrogatories. They say, how can I live in this environment? Well, if it turns out civil law lawyers are saying international arbitration, why is there so much discovery? Because they're used to very, very minimal discovery. So it depends on your perspective. What I found is most cases are just pretty, breach of contract disputes. There's actually no real dispute about the facts. And there's very little need for discovery except for maybe damages or a few issues. It's mostly about the meaning of the contract. So in many cases, you can get rid of it almost entirely or very drastically, and you're fine. However, there are cases, for example, a fraud case where there's a real basis for a fraud claim, where it's really important. So I don't like the kind of one size fits all. It should always be the international approach, always be the US approach. Let's figure out what's going to work for your case. Do you really need it here? If so, what do you need it about? And let's figure out what's going to work.
Any advice that you would have to provide a young aspirant who is thinking of embarking upon a career that follows in your footsteps?
Yeah, really, if you already have some international experience, great. But obviously, if you don't have it yet, it may be difficult to get it. But I would look for those opportunities because I think the international, you don't have to be fluent necessarily in another language, but having had the experience of dealing with other cultures, I think is very helpful because I think some flexibility of mind, being able to change gears is helpful. Second, fundamentally, you need to be an excellent advocate, both written and oral. So, of course, if you can get a job directly in international arbitration, great. But if you can't, just a job that will give you good training in commercial disputes, let's say litigation. Again, most of it will carry over. Great. But definitely you should look for opportunities. But as I said, my career has kind of been there's a lot of luck involved, but also when I saw opportunities, I went after them. It's a combination of the two.
Grant, you had, by all outward signs, a very satisfying professional life. I wonder if you could just share with us some of the things that, particularly in the field of arbitration, have brought you the greatest satisfaction, fulfillment in your professional career.
Well, overall, as I've just met amazing people, and the international arbitration community is amazing because it attracts people who are first and foremost internationally minded. They're open to other ways of thinking. You meet diverse people. So both in the arbitration and outside of the arbitration, there's a wonderful sense of just connecting with, humanity and different places, different ways of thinking around the world. So that would be the number one. Professionally, I have to say, there are a lot of highlights, and I've had a lot of good things. But I remember when I moved to Korea, 20 years ago, and I was doing my very first arbitration in London as lead counsel. And there was a British, at that time, they were called Queen's Counsel, now King's Counsel, who was the arbitrator appointed by the other side. And he absolutely lived up to the reputation of being just a really excellent, advocate and trial lawyer. And he gave me a really tough time, but it turned out we had a good way of communicating because we had different we're from different countries, and the English common law is quite different, but we were on the same wavelength. And at one point he asked me, so are you a trial lawyer in the US? And I thought, wow, it's great, because the truth is, like most people at a big firm, I did go to some trials, but hardly any. They all settle, right? That's one great thing about arbitration is they settle less often. So if you want to get to trial, well, I've done a lot of arbitration trials. So
over your career, you've obviously observed some significant changes in the landscape here in California. The profession, particularly international commercial arbitration, is continuing to evolve, and I'd appreciate your observations about how that has been transformed during your distinguished career.
Yeah, so just it's fantastic what I've seen. 20 years ago, when I went to Korea in 2000, and even when I came back in 2004. When I came back in 2004, I definitely went into trying to network among the arbitration community in California, but it was very small. There was a community, but it was like if you saw anybody new at any event, you were like really excited and say, wow, and how did you get into it? And everybody had their unique story, because there's plenty of arbitration involved in California, but there's so many law firms, it's just kind of randomly dispersed and people are not really developing expertise. It's kind of odd. So I remember 2004, there was like one conference like every few years. Well, within about 5 years, it started to be one conference every year. And now we have multiple conferences for a year. And now we have a pretty big community. And back then there was one super famous arbitrator in California and then just basically nobody else. Now we've got multiple really excellent arbitrators and counsel. So I think the growth is wonderful. It's an exciting time to be in arbitration. I think the establishment of CalArb and all that it's accomplished in its short life is a reflection of that. We didn't have enough people to create organizations like this. And of course, we'll be hosting the ICA conference 4 years from now, which is the big international arbitration sort of a conference. It's sort of like the Olympics of international arbitration. So there's a lot more work to be done, but it's been very exciting. And I have to say, as I mentioned, when I went, I've seen this twice. Actually, I've seen it 3 times now, really. In Korea, when I went there in 2000, it was tiny, unknown. 2004, it was starting to develop. A few years later, it was really on the map. It can happen. And I've seen this in California and happening now. I was in Tokyo a year ago, and it was their first big ICC conference ever. And there were 200 people all day and it was packed. And there was an excitement. You could tell the community was finally coming together. So I think in the next 10 years, it'll take off there too. So again, it's great, from a professional point of view, if there's more work for you to do. But what I really love, again, is the community. There's a buzz, there's a very collegial community of people from around the world, kind of working together to resolve disputes in a fair and efficient manner. And I find that's personally very satisfying.
Do you have any observations as to what is contributing to this sudden emergence of a really significant international commercial arbitration community in California?
Well, yeah, I mean, I don't think it's so sudden. I think it's been happening. It's been happening over the last 10 or 15 years. Um, I think the first big thing was when there used to be a California law that, or a Supreme Court decision that raised a question as to whether foreign lawyers could even appear in international arbitration in California. There was an argument that you couldn't do it. It wasn't really clear that that was the case, but it created a cloud over arbitration. For many years, our community was trying to change that law, but we didn't have enough organizing kind of power to do it. Eventually, it was a number of years ago, we got that overturned. And of course, it was significant that we got it overturned. What was also really important is it meant our community was now strong enough that we could do that, right? So I think it's really just the good efforts of a lot of people. There are two things. One, the good efforts of a lot of people combined. Second, California is, after all, one of the largest economies in the entire world, and certainly the largest economy of any US state by a large margin. And our economy is extremely international. So obviously, there are going to be tons of international arbitrations involving California companies. That was when I mentioned Korea developing international arbitration 20 years ago. Also, Korean economy is extremely international. And Koreans try to avoid a fight if they can, but if they get into one, they're not afraid to fight. So it was also a ripe market. There was a lot of potential. And the Korean law firms saw, wow, this is a great market, and they invested in it heavily. But what really happened in Korea was it was all the Korean law firms, which are competitors, working together to build the reputation of Korea in arbitration. It's, the classic, when the seas rise, all the boats rise together. Same with California. And I think it's really wonderful. I've seen all these different people at competing law firms working together to build our community. And, it's just wonderful.
Well, Grant, I want to thank you very much. You've had a most interesting professional career with a very bright future left ahead of you. And you shared some interesting observations, not only about the past, but the future for the rest of us to ponder and to contemplate how we can lock arms with you and others in this community and see the professional opportunities being expanded going forward. Thanks for being part of California Conversations. This has really been a treat for me, and I know that our viewers will enjoy not only getting to know you a little bit better, but having the benefit of your insights as well. So we're grateful for you taking the time to be with us today. And as I say, thank you very much on behalf of CalArb for being part of California Conversations.
Thank you, Chuck. It's my pleasure.